Washington. Thank you all for being here. As you can see, this meeting is being recorded, and I'll speak to that in a moment. We're excited to share information about how the university will proceed under the new Title IX regulations, which, as you'll hear us say many times, we're going to refer to as the EDFR. You can even see it on the slide. An EDFR, or Department of Education Federal Regulations Prohibited Conduct. EDFR is the short version of that. We're excited to talk to you about it and answer questions. And just so you all know, we are recording this presentation so that it can be viewed later by others working in this process. So here on this roadmap is our agenda for today's presentation. And as you can see, there's a spot at the end for questions, and questions can be asked by using the chat window in Zoom. Please keep your audio muted unless we ask you to unmute, and please keep your own video stopped. For your information, if you ask a question via Zoom, via the chat, and we end up needing more clarification or follow-up, we might give you the option of unmuting to discuss with us. But obviously, since we're recording, if that happens, your audio would be a part of the recording, as would be your video if you were showing video. For the attorneys who are present, we've been approved for 1 CLE credit for this presentation. If you haven't already done so, if you'd like a CLE credit, please email me that you attended and include your bar number. We'll also be trying to note all of the attorneys present, but we don't want to miss anyone. Yesterday, I emailed to everyone who had RSVP'd, I should say, a PDF of the slide deck, as well as an evaluation form. For those who received that, it'd be very helpful if you could fill out the form and return it to us. We'll compile them anonymously. If you didn't get that email, please just email me either during this presentation or after, and I'll be sure to get you those materials. Just a little bit more here. Speaking to item number 4, overlap. By non-EDFR, what we mean here and throughout is the other parts of the Washington Administrative Code, which is also referred to as the WAC, Chapter 478-121, that are connected to student governance policies 209 and 210. And you also hear that as SGP 209, 210. And I think that's the sum of the acronyms that we're going to deal with. So it's just kind of those 4. SGP 209 is academic and behavioral conduct. SGP 210 is Title IX related conduct before EDFR. And you'll probably see it both ways here. The EDFR elements are now a part of our WAC chapter as part 7. And finally, a quick shout out to John Hogle, who has helped us put a ton in putting together this presentation and with the tech stuff today. And many others also helped us with this content. Thank you all. Okay, now we're going to do some introductions. I'll go first. As I said already, and as probably many of you know, I'm the hearing officer for the University of Washington. That means that I preside over the student conduct hearings, whether they're SGP 209 or 210, and also be presiding over the EDFR hearings as well. And I've been at the University of Washington for just about 2 years in January. And in terms of my background, I am an attorney. Prior to coming here, I worked at a nonprofit called Team Child for about 13 years. And most of that time as a staff attorney, working and representing youth who needed access to community services. A lot of the work that I did was related to working on education services. So I represented a lot of clients in school discipline matters and also represented a lot of youth who needed access to special education services. Okay, why don't we go to Mags now?
Hi, everyone. Thanks for being here. I am Mags Alex, the Deputy Title IX Coordinator. I've been in this position for about 15 months at the university, though I've worked at the university for over 5 years. I was a Title IX investigator prior to being the Deputy Title IX Coordinator. I also, just so that you're aware, have an attorney background. I litigated in California, and then before coming to the university, I also worked in community mental health, working with folks experiencing homelessness and in jails.
Hi, good morning. My name is Ian Messerly. I'm the manager of the Title IX Investigation Office. I've been at the university for about 6.5 years. Like Mags and Dave, I'm also an attorney. My background prior to joining the university was primarily in management side employment law, and also time in the military doing both criminal prosecution and defense in the JAG Corps.
Thanks, Ian and Mags. I also wanted to do a shout out to Kara Blake. I'm one half of the hearing office, and Kara is the hearing coordinator in the hearing office. And I'm sure many of you have worked with her and know that in a case, she handles a lot of the communications, a lot of logistics, a lot of the tech. So I just want to, she's a huge part of the hearing process too. So I want to give a shout out to her as well and make sure y'all are familiar with her name and her role. Okay, so here are disclaimers about the presentation today. They apply to the content in the slides and also to the question and answer part of it at the end. Okay, so this graphic, there's a lot going on here. This graphic sums up the biggest changes in how our process is going to work or is working for EDFR. It's hard for me to explain this without going through all that we'll go through today. But the good news is that by the end of the presentation, we'll return to this slide and it should make a lot of sense. And if it doesn't, please let us know. We'll try to explain. In short, for now, what our Title IX investigators are considering, or when they're considering whether EDFR applies as they're investigating a matter that arises out of alleged conduct from on or after August 14th, 2020, there are a lot of considerations they take into account. Including jurisdictional questions for them to consider, as well as questions about the definitions that the EDFR provides for specific types of conduct. And if their answer is no, no to whether EDFR applies, then the matter is going to be handled in the same way that we've been handling Title IX based allegations since August 2017. If the answer is yes, well, that's kind of why we're all here today. And what you're going to hear is that when EDFR is determined to apply, those matters are by and large going to go to hearing, and the hearing is different. And in some ways it's very different, and in some ways it's not all that different. The previews, I guess, the biggest things are around cross-examination, which will be done directly by each party's hearing advisor. And also if a party or a witness does not submit to cross-examination, then their earlier statements can't be considered in decision-making about the case. And there's a lot that we'll explain about that. Also, matters that have both EDFR-based allegations and non-EDFR-based allegations will be handled in one case, and we'll talk about that too. So while these changes will be the focus of today, and likely most of the questions, we're going to start with some of the foundations of Title IX work at the university and a quick run through of how our process works before we add in the EDFR elements. So our guiding values in the hearing process are due process, equity, and best practices. We recognize that there are different roles for those involved, and we recognize that attorneys act as essential guardians of the rights of their clients, and they can greatly help clients convey their position and provide evidence in support of that position. Like attorneys, the university is also acting to protect the rights of students. This includes investigators and decision makers at the university. For what it's worth, we want to share that we try hard to avoid an adversarial atmosphere. Our aim is to foster an environment of respect and fairness while allowing for zealous advocacy on all sides. We try to set reasonable, equitable parameters around the advisor's role in the process. We do our best to keep in mind and to help everyone else keep in mind that many of the witnesses and parties are students and even adolescents, and try to recognize that a conduct hearing is often, perhaps always, the last place any student wants to be. So by and large, as the hearing officer, I'm following an established process that we essentially use every time. This process for hearings is based on the Washington Administrative Code Chapter 478-121. Also, you'll hear is WAC 478-121 and the Student Governance Policies 209 and or 210. Decisions about process, even ones being made for the first time on a novel issue, are based on the principles of the WAC and those SGPs, and other philosophical background about the role of student conduct at educational institutions. For those who haven't already been a part of a case, it might be helpful to know that there's a lot of discussion at the pre-hearing about process, and there's a lot of opportunity for asking questions. The pre-hearing conference or meeting is itself usually at least an hour. It can go as long as 2, depending on the issues involved. And there's also a process for motions after the pre-hearing. As another side note, the option of emailing the hearing office during a case about your questions during a case is certainly there. It's certainly something you can do, but it is subject to ex parte rules. Some questions that are just about process can be sent without sharing with the other party, but anything that gets to the substance of the case has to be shared with everyone in the case. I'm sure that's pretty familiar to you all, and the pre-hearing process does explain that much more. Okay, so now we're going to go to a fairly quick general overview of the hearing process. And this is a visual representation of the foundations and sources of our code, student conduct code, and the process. It all centers on the WAC, or the Washington Administrative Code, Chapter 478121. And if you hear someone like I just did referring to the student conduct code or the code, that's what we're talking about. Student Governance Policy 209 does not have a complainant. It focuses on academic misconduct and behavioral misconduct. SGP 210 covers Title IX conduct, and it does have a complainant who is usually, but it doesn't have to be, a University of Washington student. It's also possible that a matter will have allegations of violations of both SGP 209 and SGP 210. So this is a quick representation of the major steps in the hearing process and what happens at each one. It's definitely not comprehensive. And it probably, for the attorneys out there, it probably generally follows the process that you would see in a civil case or in a criminal case in Superior Court. One difference to flag here with the EDFR is that for EDFR, the pre-hearings are called pre-hearing meetings as opposed to pre-hearing conferences. And I think that we like that change, actually, because meeting sounds more familiar and less legalistic than conference, and thus it sounds more developmentally appropriate to the setting here. Still, it's a language change that we're getting used to, and I'm sure I'll mix them up for a while. I'll also add some very general timeframes for these major steps. So from conversion or from the start of the hearing process to the pre-hearing conference or meeting, that's generally about 3 weeks. And then a pre-hearing order usually comes out within 7 to 10 days of that pre-hearing meeting. And then from the pre-hearing meeting to hearing, again, generally it's about another 3 weeks. And then from there, between the hearing and the initial order, under the Administrative Procedures Act, the initial order needs to come out within 90 days. And frequently those orders come out sooner than that. So these are some reflections that we thought might be helpful to share. Frankly, there wasn't like an ideal place in this presentation to put it, but we still thought it might be helpful. These are some reflections on what's been effective and at times it seemed ineffective in hearings, and just sort of offer it to use or to not use as it might be helpful. Now we're going to get more into the new regulations, and I'll turn it over to Max.
Great. The Department of Education issued its federal Title IX regulations on May 6th. They became effective August 14th, giving the university about 100 days to implement them. The regulations were over 2,000 pages, most of which were preamble. The preamble, while not having the force of law, nevertheless explained how students were to implement the regulations and how the Office for Civil Rights would enforce them. Over the summer, the Department of Education responded to questions about the implementation and interpretation of their regulations in the form of blog posts. In one such blog post, the department clarified that the regulations applied to conduct that occurred on or after August 14th, 2020. To comply with the regulations, the University of Washington, among other things, needed to amend its student conduct code. Since the code is part of Washington Administrative Code, that meant we needed to change the WAC. Given the length of time required for permanent rulemaking and the time permitted to implement the regulations, our available option was creating an emergency rule. Our emergency rule added a separate Part 7 to the Student Conduct Code. We modified only 3 existing sections of the Student Conduct Code to signal where the federal regulation adjudication process, rather than the process the university had already been using, applies. I'll note too that the preamble expressly stated schools can continue prohibiting conduct beyond that defined in the federal regulations. Accordingly, we left the remainder of the code as it was written. The federal regulations require that schools follow a specific grievance process when a narrow subset of sexual harassment occurs in an education program or activity. This was defined as including locations, events, or circumstances over which a recipient, the University of Washington in this case, exercised substantial control over both the respondent and the context in which the sexual harassment occurs. The regulation specifically included 2 buildings owned or controlled by a student organization that is officially recognized by a post-secondary institution. Additionally, the federal regulations required that the alleged conduct must have occurred in the United States, and the person alleging the misconduct must be participating in or attempting to participate in the university's education program or activities. These jurisdictional requirements were codified in UW's emergency rule in WAC section 478-121-600. These criteria mean that when a specific subset of sexual harassment is alleged to have occurred on campus, in a class, in a university workspace, in connection with a conference our students attend in the United States, fieldwork and internships in the US, or in a fraternity or sorority house, the University of Washington must follow the prescriptive grievance process required by the regulations. You may have noted I've referenced a narrower subset of sexual harassment. I'll cover the federal regulations definition of sexual harassment after further discussing jurisdiction. The Student Conduct Code, as it stood prior to August 14th, 2020, established the university's jurisdictional scope. UW's jurisdiction for the purposes of its Student Conduct Code and the prohibited behavior outlined in Part 2 of the Washington Administrative Code is found in WAC 478-121-040. This is one of the sections that was modified by the emergency rule. We added a subsection 4 that states the federal regulations take precedence when specific types of sexual harassment are alleged and the federal jurisdictional criteria is met. When the federal jurisdiction criteria is not met, the jurisdiction section in Part 1 of the Student Conduct Code establishes that the University of Washington exercises jurisdiction over prohibited conduct that occurs on university premises or in connection with university-sponsored programs or activities. The university also exercises jurisdiction off campus, where the university reasonably determines that the alleged conduct adversely affects a university interest, has continuing adverse effects, or may create a hostile environment on university premises or in the context of a university-sponsored program or activity. Both the Student Conduct Code and the federal regulations allow the university to exercise jurisdiction over conduct on campus as well as off campus, so long as the alleged conduct occurred as part of a university-sponsored program or activity and in the United States. Pursuant to its conduct code, UW maintains jurisdiction off campus in additional locations beyond those covered by the federal regulations. These additional locations include study abroad programs, international fieldwork or internships, and other off-campus locations, including students' apartments when a university interest is adversely affected. In determining whether alleged conduct adversely affects a university interest, numerous factors are considered. These include, but are not limited to, whether the alleged conduct occurred in close proximity to a university-sponsored program, whether the alleged conduct involves an act or threat of violence, whether the alleged conduct was perpetrated against another member of the university community, or whether the alleged conduct raises a threat of violence that could impact another member of the university community. So the federal regulations defined the sexual harassment to which they apply. To differentiate between the federal regulations definition of sexual harassment and those definitions the Student Conduct Code already contained, the University of Washington prefaced the federally defined prohibited conduct with the acronym EDFR for Department of Education Federal Regulations. Part 7 of the Student Conduct Code incorporated the federal regulations definition of hostile environment sexual harassment, which is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. The federal regulations further define sexual harassment to include sexual assault, dating violence, domestic violence, and stalking. To define each of these behaviors, the federal regulations cited other federal laws, specifically Clery and the Violence Against Women Act. And those laws cited additional federal laws. UW incorporated these definitions into the emergency rule in WAC 478-121-605. I'll now outline some of the differences between the federal regulations definition and the Student Conduct Code's definitions in Part 2 of the WAC. The University of Washington defines the creation of a hostile environment as occurring when conduct is sufficiently severe, persistent, or pervasive that it unreasonably interferes with the complainant's academic work or ability to participate in university programs and activities. The federal regulations define a hostile environment as occurring when conduct is severe, pervasive, and objectively offensive. So both definitions incorporate severe and pervasive. However, the UW definition uses persistent, where the federal regulations use objectively offensive. Probably of greater significance, though, is the university's use of the conjunction or, as compared to the federal regulations use of the conjunction and. This makes the federal regulation definition narrower because conduct must be all of the three things: severe, pervasive, and objectively offensive simultaneously, instead of under the UW definition being either severe, persistent, or pervasive. The federal regulations definition of sexual assault is also narrower. Its definition of a sexual assault is that used by the FBI's Uniform Crime Reporting System and describes penetration or sexual touching for the purpose of sexual gratification. The university's definition of sexual assault is sexual conduct that exceeds someone's consent, where sexual conduct is any intentional touching of the intimate parts of another person's clothed or unclothed body. The federal regulations definitions of dating violence and domestic violence are narrower than the definition of intimate partner violence that was already and remains part of the Student Conduct Code. This is because the federal regulations require an act or acts of violence. The university acknowledges that abuse may not be physical in nature and may involve additional forms of abuse, such as that which is emotional or economic. UW also continues to prohibit additional conduct, such as sexual exploitation, for example, sharing intimate images without permission, and indecent exposure.
So under the EDFR, the standard of proof used at the University of Washington will remain preponderance of the evidence. I assume, I sort of am aware that the criminal court form is likely the form that most attorneys are accustomed to, and we recognize how different this standard is from the standard used in criminal court proceedings. In the hearings at the University of Washington, a preponderance of the evidence may be found even when there is also a reasonable doubt. So EDFR matters will most likely go to hearing. That's different from SGP 209 or 210 matters, where the investigator has to make a determination about two factors. Factor one is whether there's a preponderance of the evidence to find responsibility. And factor two is if there is a preponderance, whether suspension or dismissal might be appropriate sanctions. Some 209 or 210 matters are resolved by an investigator determination that those two factors are not present, and the investigator then writes an initial order to that effect. And that initial order could mean a finding of no responsibility, or it could mean a finding of responsibility and a sanction that is not suspension or dismissal. But resolving the case through an initial order from the investigator is generally not possible for EDFR matters. So that's why we say that EDFR matters are more likely or most likely to go to hearing. A few other notes on this slide. So around agreed settlement, while of course the settlement would involve a complainant and a respondent, it's my understanding that they also need to involve the investigator So if you're representing a student and communicating with the other party's advisor around settlement, at some point you will need to involve the investigator in those discussions. In terms of informal resolution options, the university currently does not have any robust informal resolution approaches like restorative justice approaches. We don't have any of those in place currently, but there is consideration and interest. And cross-examination notes, the very short version is that, as I think I said earlier, cross-examination will be done by direct oral questioning by the hearing advisor, and statements by a witness or party can't generally be considered unless that person submits a cross-examination. But we'll get into this in much more depth later on.
So the federal regulations preamble explicitly gives educational institutions permission to regulate conduct that is not included in the Code of Federal Regulations. When or if schools choose to regulate additional conduct in additional locations, they are not required to follow the regulations prescriptive process. The university will continue enforcing its student conduct code and prohibiting the conduct defined in Part 2 of the code, as it has since 2017. The federal regulations definition of a formal complaint does not coincide neatly with the federal regulations definition of sexual harassment or the federal regulations jurisdictional scope. A formal complaint is simply a written complaint of sexual harassment. The definition of a formal complaint does not require that the allegation fall within the narrower definition of sexual harassment contained in the federal regulations. Thus, some formal complaints will be dismissed for the purpose of the federal regulations grievance process. Part 7 of the WAC covers both when such a dismissal must occur and when a dismissal may occur. By and large, when a dismissal for the purpose of the federal regulations occurs, the university will likely proceed by investigating allegations of prohibited conduct that fall under Part 2 of the Student Conduct Code and utilize the process that it has used for these allegations for the last several years.
Hi, good morning. I'd like to next spend a few minutes speaking about the investigation process when a formal complaint has been made to the university. A formal complaint, according to the EDFR, is a complaint made in writing by a complainant, which alleges that a complainant has been sexually harassed by a university student and requests that the university investigate. As we learned, however, not all formal complaints fall within the EDFR. For example, if the complaint is made by a person who is not attempting to access the university, in other words, if the complainant is made by someone who is not a university student, for example, if the complaint is about conduct that has occurred off campus and is therefore not within the university's programs or activities, or if the conduct that is alleged just doesn't meet the EDFR definitions of sexual harassment. So if for any reasons a formal complaint doesn't fall within the EDFR require that complaint must be dismissed, as Meg's described. When our office dismisses a formal complaint, we'll notify both the complainant and the respondent, and we'll state the reasons for this dismissal. And this decision by our office can be appealed to a neutral party. Also, as Mags described, in some cases, the conduct that is alleged may violate university policy, but may also require dismissal under the EDFR. I think, as I mentioned, one way this could happen is if the complainant and respondent are both university students, but the alleged misconduct occurs off campus. So in a case like that, we'd expect to proceed with an investigation under the Student Conduct Code, but we would also need to dismiss the complaint for the purposes of EDFR. So what would happen is we would notify both the complainant and the respondent of both things, that there will be an investigation, that it's proceeding under the Student Conduct Code, but we're required by the federal regulations to dismiss the allegations for purposes of EDFR. In other words, the university would investigate the allegations of misconduct, but we would not be using the procedures required by the EDFR because the EDFR do not apply. And again, if the complainant or the respondent disagreed with that determination, and they felt that the EDFR did apply, that decision could be appealed. In cases where the EDFR do apply, there are a few things that we would like you to know about the investigation stage that differ from processes that we've used in the past. First, after the investigator has completed their evidence gathering, the investigator will write a preliminary investigative report that summarizes the evidence gathered. The investigator will then provide that report to the complainant, to the respondent, and their respective advisors. Under the process that existed prior to the EDFR, there was no preliminary report that was circulated before our office created its final report. In other words, there was only one report that we did. When this report is shared, it cannot be shared outside of the complainant, the respondent, and their advisors. Another change under the EDFR is the timing of when our office provides access to evidence. In cases where the EDFR apply, the investigator will provide access to all evidence related to the allegations, and will do this at the same time that the preliminary report is provided. The parties will have time, usually about 10 days, to respond if they want to, before this preliminary investigative report is made final. Even once the investigator has finalized the investigative report, that final investigative report is not the last word on the matter and does not represent the university's decision on the ultimate outcome. That happens at a hearing. But it is, that final investigative report is required by the EDFR before a matter proceeds to a hearing. This final investigative report will always be issued at least 10 days before any hearing is held, and much likely much earlier than that. Party interviews are critical parts of the investigation, and correspondingly, during the investigation process, an investigator would typically expect to speak to each party at least twice, and sometimes more if the investigation demands it. And during these investigative interviews, which a complainant or respondent will be notified of in advance, the complainant or respondent may be accompanied by an advisor, and that the advisor could be an attorney. During these meetings, an advisor can't speak on behalf of the complainant or respondent during the interviews. In other words, an advisor can't answer the investigator's questions for the party. We need to hear this information directly from the party themselves. But advisors are welcome to attend the meetings. They're welcome to observe the interviews. They can take breaks to consult with their clients. And if advisors have any questions about the process, from our office's point of view, we'd encourage them to ask these questions in advance and contact the investigator in advance of the investigative interview. This makes the best possible use of that time during the investigative interview that we have with the parties. This is the parties' opportunities to explain their recollection and perspective on the allegations, and we hope that the meetings can be as focused on that as possible. Additionally, during the investigative process, complainants and respondents may present evidence and suggest the names of people who investigators can consider interviewing. In summary, for the investigative part of this, the goal of an investigation is to gather and organize relevant information. For this reason, investigators expect to hear directly from the complainant and the respondent themselves, and not from advisors speaking on their behalf. And it may also help you to know that investigators at the university don't have subpoena power or the power to compel parties or other witnesses to produce evidence. So for that reason, it's helpful when the parties produce this evidence themselves, and it's also helpful when they do so as early in the investigation as possible. For example, if there's an allegation of sexual assault that occurred on a particular night, it would help the investigators if the parties provide, as soon as it's feasible, any evidence that they may have. For example, Instagram messages, photographs, phone logs, timestamp purchases, or anything else that may provide relevant information.
Thanks, Ian. So we've already been talking about a mixed claim case during the presentation. So the next few slides will visualize that in a different way that hopefully is helpful to understanding. So the circles that you'll see represent the conduct being alleged in an investigation. And here first is a circle that represents the amount of conduct that allegedly violates the EDFR-based rules. And as you can see, there are 2 allegations under the EDFR coming out of that conduct. So now this slide, we've got the conduct that allegedly violates the non-EDFR-based rules, and you see the allegations coming out of those. And here they are together. And it's not an accident that the SGP 209/210 based allegations, that circle is larger than the EDFR one. It's likely that 209/210 bases for allegations are more expansive for reasons that include, it might include off-campus conduct, or it includes other conduct that's not covered by the EDFR. So this slide is a summary of notable aspects of our process when there's a mixed claim. If there are differences, those differences will also be noted in the parts of the initial order dealing with each type of allegation. And in our next section, we'll start talking about these EDFR processes. Okay, so now we're going to go into depth on some of these issues. So our first topic is advisors. And there's a lot of text on this slide, but I think it's actually pretty straightforward, so I'm not going to read through it, but I will note some of the keys. As with SGP 209/210, under EDFR, a party can have 2 people with them during the hearing process. The terminology has changed a bit from advisor to hearing advisor, and from confidential advocate or respondent resource to support advisor. But I think by and large, these are actually going to be the same roles and the same people for the most part. I do want to note the university can provide both types of advisors under EDFR. And a hearing advisor under EDFR can be an attorney, but doesn't have to be. If the hearing advisor is not an attorney, then they can't actively advocate for the party in the process like an attorney can. However, the hearing advisor, whether or not they're an attorney, has to be the one to ask that party's cross-examination questions. The party themselves can't directly ask those questions. Just a few things to add from the previous slide to on this one. The University of Washington provided hearing advisor when those are provided won't be an attorney. And it's likely, my understanding is that likely it would be a conduct officer from one of our student conduct offices. And in my opinion, I think that's of great benefit to the students, because our conduct officers are trained and have very special experience and expertise in working closely with students, and they're very knowledgeable about student conduct overall and the conduct process. So this slide lays out what a non-attorney hearing advisor can and cannot do in a case involving an EDFR-based allegation. It's not on here, but also a non-attorney hearing advisor can't submit motions or respond to motions. The party themselves would have to do that. So this slide lays out what an attorney hearing advisor can do. And essentially, they can do what you generally expect an attorney representing a party to be able to do during an administrative hearing process. I think it's pretty straightforward. As you can see at the top, by attorney, what we mean is either someone licensed in Washington as an attorney, or someone who's licensed elsewhere and has gone through the PROHIBITED process in Washington. And that process, as far as I can tell, it's not difficult, but it's also not something that can be done in a day or two. It requires some advanced planning and work, so it's not something that should be left until the last minute. So here are some general expectations. I think these are pretty basic and they're probably not surprising. And in general, my experience, we haven't had any problems with any of these. So a lot happens and is covered at the pre-hearing meeting and through the pre-hearing order. And we'll be adding explanation of EDFR impacts and processes in that process. clearly, one of the things we'll do is we'll clearly identify which allegations in a case are based on EDFR and which are based on SGP 209 or 210. This table or something like it might be a part of how we do that. So now, finally, perhaps we're going to get into the cross-examination process under the new regulations. And process-wise, this is the biggest difference in what a hearing before the new regulations look like and what they will look like now, again, if they involve allegations based on EDFR. So first, this is the process that we've been using under SGP 209 and 210. And it's the process we'll continue using for cases that are just 209 and 210. If you've been through a hearing in the last few years, I think this will be familiar to you, but I'll try to give a quick explanation. So step one here is just direct question between the hearing officer and the witness. So the witness answers questions about what they know about the case. The hearing officer asks those questions. The witness just answers. 2 and 3 are the cross-examination part of a witness's testimony. And what we do is we use, so let's just say witness testifying, the complainant is going to go first. What the complainant or the complainant's advisor will do if they're an attorney is they will type in their question using Zoom chat. And the hearing officer will read that question, consider whether it's appropriate, and then we'll ask the witness the question. And during that period is also when any objections come up and any objections are decided upon. And I will note that we've used this process of using the Zoom chat before COVID. Even when we're all in person, we would have computers there for everyone, and they would type it in and the hearing officer would read it. And we're also using it during COVID. But essentially, the party will submit the question in writing, and then the hearing officer is the one who asks it out loud. Okay, so now we're under the EDFR process. And the first step here is actually the same as it's been under 209, 210. And to be real specific about it, the hearing officer asks the witness questions. But now, this is where it gets different. After direct examination is done, each party gets an opportunity to cross-examine the witness. This is done by the party's hearing advisor asking the witness questions, and this is part one that we can see right now. In the case of a hearing advisor provided by the university, the party themselves will need to provide the questions that then the hearing advisor will ask. Once the question is asked, and again, to be very clear, it's asked out loud. Once the question is asked, there will be a pause, and that's when the hearing officer will make a determination about whether the question is appropriate. And by that, I mean, whether it's admissible under the rules, whether it's about something relevant, essentially. This gets to part two in the middle. And this pause, though, is also when other parties can make objections about the question. So, yeah, so part two, there can be an objection. The hearing officer is on their own. They're going to evaluate the question for appropriateness, but they're also going to hear out any objections, have any discussions about objections that need to happen. And in the end, either the question will be determined to be appropriate under the rules, in which case we'll proceed to the next slide or number 3, or the question will be determined to not be okay and won't be asked. And then you go back to 1. The question's not appropriate or it's not fine, the hearing officer will share what the problem is. And it's possible that the hearing advisor will then try to cure that problem in a follow-up question, which is fine. That's the process we use now as well. For now, let's proceed with a question that was appropriate and what the witness is told to answer. And essentially, you're here at the end where the witness answers the question. And once that happens, you start over with a new question from the party's hearing advisor until they have no further questions. Then you go to the other party. And that's essentially how we're going to proceed in cases that involve EDFR-based allegations. Under the new regulations, admissibility is mostly, not entirely, but mostly about relevance. Duplicative questions may be determined to not be relevant. And this includes questions or ground that's already covered in questioning by the hearing officer, or by another party. So an example of a duplicative question, let's say there's a scenario that involves communications between the parties over Snapchat. So repeated questions about whether a party saved the snapshot, like, did you keep it? Did you screenshot it? Did you print it? Did you preserve it in some other way? Obviously, whether all those questions are duplicative might depend on the answers that the witness is giving, but if the witness says the first time, I did not keep it, it's gone, then that should probably be it. So on the bottom, there's this line about disruptive interfering behavior. Some of examples of that could be, raising one's voice, trying to attack, intimidate, or harass the other party or the witnesses. Frankly, I don't anticipate any of this being a problem or of removal being necessary. If there is a problem, I think in most scenarios, there'd be some sort of warning and discussion about it first. So now we're going to cover another major difference with the new regulations, and this is probably the biggest evidentiary issue. And you all already may know this, there's a lot of confusion around what this part of the new regulations means and how it works. But here, as we understand, are the keys. If a person does not submit to cross-examination, their statements are not admissible for purposes of considering the EDFR-based allegations. So what that means in practice, that means the hearing officer cannot rely on such evidence, meaning the statements, when the hearing officer makes factual findings or legal findings. Statements encompasses statements the witness or party made to other people, statements they made in social media or in text, or even their statement to an investigator. Keep in mind, this rule does not impact whether statements can be considered for any non-EDFR based allegations. So a comment on the second bullet. An example of this might be text messages sent by a respondent to a complainant, and those texts are the basis of a stalking allegation. In a situation where the respondent does not submit to cross-examination, those texts can be considered and relied on when making findings of fact for EDFR-based allegations because the texts themselves are the statements. I hope that makes sense. We'll have time for questions, so we can definitely come back to it if it doesn't. To complicate it slightly, if that same respondent during their investigation told the investigator, something like, yeah, I was stalking the complainant for those 2 weeks, for sure I was doing that. Right, so that statement has been made to the investigator. If that respondent later doesn't testify or submits cross-examination, their statement to the investigator can't be considered for EDFR-based claims, but at the same time, the actual text can be. So this slide is trying to play out what happens to evidence in a case when one or more parties does or does not submit to questioning. For right now, I'm just going to say that what the hearing officer can consider when making decisions about responsibility depends on who testifies. And there's definitely a lot going on with this chart, but given some time with it, I think the chart explains things fairly well. If there is time or if you'll have questions about it, we can definitely come back to this slide in the questions portion. And I'll note that I'm aware that it's 10:49 and you all might be aware we still have some slides left to go. I think we can stay a little over time if we need to get through questions. EDFR largely holds relevance as the only admissibility criteria. It's actually not that big of a departure because relevance has been central to 209 and 210 matters as well. The big exception, which we just talked about, was the cross-examination requirements. Otherwise, we don't expect a huge difference with admissibility with the EDFR process. This slide and the next one, they list some areas that might come up. I'm not going to talk through them, but we thought it might be helpful to be able to see them side by side. So you got this slide and also this one. So again, we can come back to these if you all want to or need to with questions. So just as we will explain and describe the differences between EDFR-based allegations and non-EDFR-based allegations during the hearing process and in the pre-hearing order, the initial order will do that too. Now, to be very clear, it's specifying the differences in how those are accounted for in the order. So now we're back to this slide, and hopefully this makes a lot more sense now. Let us know if it doesn't. So we're at the point for questions. I'm going to leave this slide up for now because it might be a helpful reference or starting off point for questions. We could definitely go back to other slides though. I'll also add that questions don't have to be limited to EDFR. If you have other questions about Title IX, about investigations or the hearing process, please submit those as well, and we'll answer as best we can. Thanks. So we have a question. I'll read it out loud for everyone, but it should also be visible in the chat. Does this mean that a statement from a party will not be viewed as an admission by a party opponent if they do not submit to cross-examination? I will hazard an answer to this, but I guess my direct answer to the question is I'm not sure, but I'm also not sure that it matters. I think it could be viewed as an admission by a party opponent, but if the person doesn't submit to cross-examination, it's not going to be considered, or it can't be considered for EDFR purposes anyway. I don't know if Mags or Ian, if you have a different take on that or anything you want to add.
I mean, I think the most straightforward way to answer that question is, practically speaking, yes, that's what it means. The Department of Education has issued regulations that prohibit a person's admissions from being used against being admitted as evidence in a hearing if that person who made that statement does not submit to cross-examination.
Yeah, I'd add that I think that one of the department's goals with EDFR was to simplify things. And that's why I think Mags has worked on this a lot more than I have, but that's why I think they've really tried to make it just about relevance. And if you don't testify, it doesn't come in. Now, whether that actually makes things simpler, whether this makes sense, that's a separate question. But I think from that, taking that standpoint, that's kind of the approach that they took, and that might be helpful in trying to understand how exceptions that we might be very familiar with maybe don't matter so much now under this process. Feel free to chat in questions. Oh, okay, great. So the question is, does a hearing officer have the ability to disallow a cross-examination question even if there's no objection by the other party? Mags or Ian, you want to jump in? I definitely have an answer, but I don't always need to answer first.
I can jump in. My answer, not being the hearing officer, my answer would be yes. The hearing officer can decide that a question is simply not relevant, and it doesn't require an objection from parties. The federal rules, the way that the questioning will happen under this new process, the reason that the hearing officer actually has to go ahead and tell a witness to answer a question, because the federal rules require that in the preamble. So there has to be a statement from the hearing officer telling a witness whether or not they're allowed to answer a question. We're not simply putting that in just to make sure that the assessment is clear and on the record. It's actually a requirement.
Thanks, Max. And I would also add that it's my understanding the hearing officer can disallow a question in our hearing process when EDFR is not involved. So if it's just 209 or 210 matters, that's been my practice. And I don't think anything has changed with that. We're not seeing a lot of other questions. we'll give it another minute or two if y'all think of a question. And again, it doesn't have to be about the EDFR, but it can be, obviously. And if y'all want us to go back to a slide to ask questions about it, we're happy to do that. Hopefully the relative lack of questions means it all makes sense and this is very clear, which we hope it was. So we got another question. And that question is, if there's a contemporaneous criminal investigation and or prosecution on a sexual assault case, for example, can and will the University of Washington share information learned as part of its investigation or hearing?
Dave, I have some experience with how that's worked in the past, and there have been cases where the police department has subpoenaed university records, and we do respond to those subpoenas. So that's how it's worked in practice. We there is no sort of practices of us volunteering this information because there are student privacy laws that would prevent it, but we do respond to subpoenas when we're required by law to provide that information.
Thanks, Ian. Yeah, I don't have anything to add to that. That's very helpful. So question, do you see the potential for any conduct happening anywhere falling under University of Washington jurisdiction if both parties become students? So it sounds like with that question, the conduct happened before the parties became students. I think, yes, thank you, Chris. I think for EDFR, and Mags and Ian, correct me if I get this wrong, I think for EDFR, that sort of scenario, that conduct would not fall under EDFR, most likely, unless it's a scenario where the conduct happens and then there's ongoing conduct that happens after. But then the EDFR case would be about the conduct that happened after.
Yeah, I think that the easy answer is whether the EDFR processes would apply, and the answer to that is, I think, pretty clearly no. I think it's also very unlikely that the university would assert jurisdiction under its own policies for behavior that occurred prior to someone being a student. My understanding of the student conduct code is that the conduct must be committed by someone who meets the definition of student. So if the allegation is applied to conduct that occurred before the alleged perpetrator is a student within the university's definition of student, then I'm not sure how the university could assert jurisdiction, and I frankly not sure why we would want to do that, but I think that would be my response.
So there's a follow-up comment from Chris. Summer breaks pose the gray areas. Here it seems students have problems away from school over summer break.
In cases over summer break, when a student has been enrolled and there are plans for them to be enrolled again in the autumn, they're still a student. They don't stop being a student just because they're away from the university. So they would still be a student. So the university's jurisdiction could apply to things that students do over break. But I would say that's probably how far I'd want to go with it right now, is to say it's possible. It would depend on what the misconduct is, who the alleged misconduct was against, and what the connection to the university actually was. It's not a given that it would apply, but it certainly wouldn't be a bar.
And I've received a separate note that student conduct code applies from the time of admission, so that might help define like when someone actually becomes a student at the university. And that might be reviewed on a case-by-case basis. It's great, we're getting tons of questions now. Let's jump to the next one. In a hearing where there's both EDFR allegations and non-EDFR allegations, will the hearing be bifurcated, like ask questions the current way for some of it and then EDFR way for the other part of it, or will all questioning be done under the EDFR way? And the last part is correct. It will all be done under the EDFR approach. So the hearing itself, the process it'll look like an EDFR hearing, and that's what it will be. It's in the initial order where if there are differences in terms of what evidence is admissible, that's where things will be different. It'll still be one order, but there will be some differences identified in that order to show how those different evidentiary standards are being applied. Okay, so next question. With respect to sexual assault cases, what is different now than it was a year ago with respect to cross and standard of proof? Are there any differences? What would be the major differences? I'll try to answer this and y'all jump in. I think what's different for an EDFR case, so this, in terms of cases that don't involve EDFR, nothing has changed. But if it's a sexual assault case that meets the EDFR definition, then all the differences that we talked about in the presentation, the cross-examination being done directly and orally, the requirement that the author of a statement submits cross-examination, those things all apply. The standard of proof does remain the same at preponderance. I think those are the major differences involved. Mags or Ian, do you want to jump in on that one, or should we move to the next question?
I think that's a pretty accurate summary, Dave.
Okay. All right, it's great. All these questions are coming in. So as a follow-up to the previous question, if, for example, a person decides to not participate in the University of Washington investigation or interview because of a pending criminal case, then his or her statements made prior to the University of Washington case beginning will not be used under an EDFR rule. I would clarify that to say what really matters is whether they testify at the University of Washington hearing, and maybe the question sort of presumes that if they're not going to participate in the process at all, they're not going to, the investigation process, they're not going to participate in the hearing process either. So yeah, hopefully that's clear. I don't know if you'd add anything to that, Ian or Mags.
The only thing I might add is that there may also be allegations that fall under the Student Conduct Code that are not EDFR in nature, and so then different evidentiary standards and rules would apply. Or not standards, but different rules would apply as to the evidence.
Next question, will the fact finder be a panel or the hearing examiner? The fact finder will be the hearing officer at this level. If you request administrative review from an EDFR case, it's the same. It's not the same, but it's essentially the same sort of structure as we've had for review for 209 and 210 cases. But for the full hearing, or the hearing under the EDFR terminology, the fact finder is just one hearing officer, and that hearing officer both does the fact finding and the sanctioning. Give it another minute or so for other questions. As we're waiting, I'll just repeat again, if you didn't receive the PDF with the PowerPoint slide deck, please send me an email. And also you can get the evaluation form. And if you're an attorney who wants a CLE credit, please, if you haven't done so already, email me that you attended. I think we have a good sense of it, but it's sort of hard to track as it goes. Email me that you attended and email me your bar number. and we'll submit that to WSBA. Okay, good. We got another question. If the respondent participates in the investigative interview and testifies at a hearing, the university would turn over materials from that process in response to a subpoena. That I like how that question was sort of written in a cross-examination form. Would the university turn over the materials? I don't know. Ian or Max, do you have a sense of that?
I mean, I expect we comply with subpoenas when we're required to by law. So I can't think of a reason, sort of in general, to respond any other way than yes. I would expect that we comply with subpoenas.
Yeah, that makes sense.
I will add to that, when I had received search warrants for the investigations that I had conducted, what we generally do is notify the students whose records are being requested so that they have an opportunity to file a motion to quash the subpoena with a court. So students are generally made aware of it, and we won't turn over records without at least notifying the student that we received the subpoena and have to do that.
Got another question, which I'll say I think it's a great question. It sort of points out that this presentation is really about the EDFR, not about everything about hearing process. So there's definitely, I think, stuff that we didn't cover that I'm sure is coming up for you all. So this question is, would it be held against the respondent if he or she does not answer questions? And is there a presumption of innocence? Again, great question, very appropriate. It would not be held against a respondent who doesn't answer questions, and that is something that we would cover in the pre-hearing. It's in the code. So not answering, that's not held against you, but the hearing officer does still make decisions based on the evidence that they can consider. There is a presumption of innocence that the EDFR states explicitly and is in that part of the code. And I think is in the other parts of the code too. But that is essentially how we proceed. Now, if Ian or Max, if you have anything to add to that.
No, that's accurate.
Again, great question. There's, I'm sure, stuff that we didn't cover that you would see in a pre-hearing conference, which fortunately or unfortunately also involves a PowerPoint. But it does cover a lot of ground to sort of explain the process and the rules. Well, we'll give it about 30 more seconds. If you have a question, please type it in. Otherwise, thank you all for being here. I hope this was helpful. It's great to see everyone joining this training. It's a new process. There's a lot to it, and please feel free to ask questions. Okay, I guess we'll end it there. Oh, actually, one more point. We are going to post this recording on our website. I don't know where though. Max, do you know where this will be posted ultimately?
I am not certain. We've posted some recordings of community conversations we've had at UW through the Title IX website. So we may post through that, or we may also post this. The hearing office does not have a website at this point in time. So it could also appear on the Title IX investigation office. If you're interested, let us know that you would like to review a recording, and we can notify you where it's been posted when it's ready.
Thanks, Max. Got another question about who's the best person to ask questions of in the future. It's a very fair question, since I said the email with questions. So I have two answers to that. If it's during a case, then follow the ex parte rules that I talked about earlier. I think the hearing coordinator, Kara Blake, or myself, hearing officer, that's appropriate for asking a process-based question. It's possible because ex parte rules, the question will be shared with everyone. If it's not in a case, I think it's much more wide open. I think emailing either myself or Kara would make sense, but I also think emailing Mags or Office of Title IX Coordinator would make sense. I don't know, Mags, if you would change that answer.
People are welcome to email the Office of the Title IX Coordinator. We can easily be reached. Some of you I know have my email address, so I'm happy to answer questions. Otherwise, title9@uw.edu. And if for some reason we're not the best people to answer your question, we can refer that to the investigating office or the hearing office, or follow up with them directly and get back to you. So the Office of the Title IX Coordinator is happy to answer any questions related to these federal regulations. And we have received many since these rules came out.
Okay, well, thank you all so much. Have a great rest of your day, and happy Thanksgiving next week.
Thank you, everyone.
Thank you for attending.